So if you wouldn't mind holding all of your questions till the question and answer period, that would be most appreciated. Ken Hunter has come here from California. He is just recently become a native of that state because he was formerly in Idaho and has done a number of years of research relative to issues relating to licensure for a driver's license, taxes, tax abatement, the whole program. I have looked at this particular concept through a number of different programs and have been on an educational learning curve, if you will, over a period of time that has set me into further and further dealing with constitutional issues. I must admit that after having heard and seen a number of different actions, that I am well pleased with what I have heard on a tape that I received from one of Ken's associates out in the California area. His name is Rich Praley. Rich sent me one of the tapes, and I in turn heard it so much in tune with what I was learning about that I have played it and played it and played it. As a result, I feel as though that Ken Hunter's presentation is probably a cut above everyone else's that you will find. There are going to be those who might be skeptics. A lot of people are going to say, in essence, I am not quite sure, and it may have to have a period of time to sink into your mind before you're going to be able to settle in your own mind what you want to do. But I think that once you hear the presentation, you're going to be adequately informed and appropriately astonished at some of the findings. And now on to the program. Ken Hunter.
Hi. Can everybody hear me pretty well?
Yep.
Back and back? Okay. Usually I don't need a mic. I usually kind of get louder and louder as we go on through this thing. If you came here today to hear theories, opinions, and conjectures, you're in the wrong place. If you came here to hear about the tax code and taxes, you're in the right place. The only thing I ever do is talk about taxes. The code, particularly, and that, I didn't make up the code, Congress did. But I use it. And we're well versed in that area, and we have no qualms with sitting down with the IRS and talking about it. As a matter of fact, are there any IRS agents here today? Well, that's too bad. I educated two of them at my meeting over in Phoenix, Arizona, and the only thing they had to say after the meeting was that, and they put this, by the way, in an affidavit going back to the district director's office, that they attended my meeting in Phoenix, Arizona, and the only thing we could see Ken Hunter doing was teaching people how to obey the law. I've talked to assistant U.S. attorneys out of Ben Franklin Station, Washington, D.C. They have the same opinion of me, that I do nothing but talk about the law and teach people how to obey the law. Paul Sherritt down at Ben Franklin Station, assistant U.S. attorney tax division, he said there's only one thing wrong with what Mr. Hunter does, is he wants us to obey the law as well. It's kind of a unique concept. But that's the only thing we've ever asked these people to do, is obey the law. If we force them into obeying the law and compelling them into doing it, we find a very unique situation happening. All of a sudden they start sending you out letters like, you're not liable for filing. More or less, don't call us, we'll call you if we need anything. All kinds of different phrases like this that they use to send out to you, just more or less telling you, go away and don't bother us anymore. But anyway, all across the United States right now, taxation is getting to be a problem. And there's a lot of problems in this area. When I was down in Phoenix, Arizona, there's a lady down there that her and her husband have worked on the same job for the last 10 years, and they have max deductions taken out of their checks, both state and federal. And 3 years ago, she got back $100 and some odd on both state and fed. Last year, she broke even. In 1992, she had to pay $360 some odd, yet there was no tax increases. Okay? No tax increases. This is what we've heard and heard and heard and heard, no tax increases. If you haven't really studied Hillary Clinton's President Bill Clinton's deal, yes, taxes are going to go through the roof, folks. I mean, they're going to go sky high. And that was before this Mississippi River thing. They haven't even calculated what that's going to cost yet. They have absolutely no idea. But they were telling us we had it calculated at 24% on an average family of earnings throughout the year, 24% was going towards taxes, federal taxes of some sort. And the study now shows that's jumped to 36% of what you're going to be giving away. And after they calculate this, after they add the $780 billion that they kept off the budget, which Ross Perot was hollering about, because of the federal savings and loans, they kept it off, so they haven't even calculated that to us yet. And now with this Mississippi disaster and all that, you can probably see taxes run up somewhere around 52, 53%. It's going to be extremely high. But somebody's going to pay the tax, all right? But right now, what we're seeing all across the country is that the newspapers are bashing the IRS. They're getting after them now. The judges and the courts are ruling against the Internal Revenue Service for failure to obey their own codes and that sort of thing. And it's getting to be a unique concept to force these people to obey the law. And I'm going to show you that law today. I've showed this to people all across the United States. They come up to me and they say, you know, I've been at this for, well, the people down in Columbus, Ohio. I came from there, and they told me that they learned more in 3 phone calls from me than they did in 5 years of listening to these other people across the country. They got theories, opinions, and conjectures are real nice over coffee or up in the room. We were just up talking about opinions up in the room before we came down here. And that's real good. But if you try to take these and do them in front of the IRS or the court or wherever, you're going to lose. You're going to lose badly. And the only thing these people understand is the code. And when you get down to who is actually taxable under this code, and I'm going to show you today, I'm going to show you exactly who is exactly where you are in that code. And I didn't make this thing up. I just obey it. Congress wrote the thing and said, here it is. And court after court after court now is banging the IRS because they don't want to obey the law. They've repeatedly told us that they're not subject to the law. We've repeatedly told them, now you are. And now the state, even the state courts are getting into the action and saying, hey, if you want to rule that some kind of a fraudulent conveyance was done here when you transferred your property into a trust, you have to use state law. And state statute of limitations apply on these seizures. And that's where we're coming at them. We're flat, just smack dab coming at them. Now this here is a cartoon that came out of one of the major newspapers on the West Coast. Now 5 years ago, they would have never even thought about printing something like that. Would never even thought about it. But now here it is, see, and they're after it. Here's another one here. And this is where we're really hammering it. And I haven't put this down into transparency yet, but if you can see it, here's Uncle Sam standing here in his Uncle Sam uniform. And it said, and he's in a police lineup. These 2 are policemen, and this guy here is pointing the finger. He says, there he is, officer. He's the one who robbed me. He's the 1040 bandit. 5 years ago, you would have never seen this in publication. But 1040 bandit is exactly what he is. Matter of fact, if you want to ask your congressman when they ever passed the 1040 tax. You're going to be surprised what he's going to tell you. He's going to tell you there is no such thing. Yet they seized house after house after house on a 1040 tax. And I'll show you that in an actual court case as we go to an end of this thing. So as we go on through this, as we start here, I'll show you some documentation, some things that are going on across the country. I'll share them with you. If you want copies of them, get a hold of Doug and let him know what you want. I'll get copies back to you as soon as I can anyway. But there's fights right now going on and arguments against the government all across the country. One of the big ones now is coming about is whether or not you have to give your Social Security number to get a driver's license. This is a big thing right now, right? Well, here's a young man that just flat got tired of it. He sued him. And he won. He flat won. They cannot request that Social Security number. If they're doing it in your state, get after them. Larry B. Kraft, an attorney out of Huntsville, Alabama, has a very nice brief as to how the Social Security came around, the voluntary status of it. He's got it very well documented. And we're hitting the states with this and saying, hey, where did you ever get this doggone authority? And it's amazing what they'll tell you. You know, they just simply say, well, we'll make an exception in your rule in the interest of justice. It's always in the interest of justice. So anyway, here's another article that came out of the papers in the Midwest. It's this one here. And it says, IRS is getting tough on delinquent taxpayers. And this was written by several tax lawyers out of the Los Angeles area, several CPAs. And what they're asking you to do in the Internal Revenue Service right now, they have a program called Get Straight. And it has to do with getting amnesty. If you owe them any money or they claim you owe money, you can go down and get amnesty. There's only one problem with getting amnesty, is you better get yourself some immunity as well. Get the immunity before you ever start talking about amnesty. Because people that went and applied for this program have wound up being criminally prosecuted for willful failure to file, income tax evasion, different things like that. But anyway, this thing was written, I'll read part of it to you here. And it goes on down, of course, to tell you that when you come in, they want you to be honest with them, they're going to be honest with you, and such things as that. But the biggest thing you want to do, anytime you're talking with the Internal Revenue Service, or any federal agency that has the authority to arrest you, or they assume they have the authority to arrest you, is to find out who in the world it is you're talking to. And this one tax attorney here who has defended several tax people in the LA area, he said if you're asked to come in for an interview, you need to consider the contact far more serious, says Bernard Oster, and he lists the law firm that he's part of. Before you open your mouth, you should find out the names and titles of the IRS employees you'll be talking to. Oster says if you're talking to a revenue agent or a revenue officer, you're still dealing with the IRS civil compliance section R. Chances are they just want you to file and pay. But if you're being interviewed by a special agent, you're dealing with the IRS criminal unit. He notes similarly, if an IRS agent shows up at your door and reads you your rights, you've got a criminal tax problem. At that point, you need to suture your lips together and go see a criminal lawyer. Well, I don't agree with the last section of that. But you better learn to do three things. When you see a special agent hammering on your door, he's from CID, folks, you better learn to do three things. And that's shut up, be quiet, and don't say anything. If you can do those three things, then you're in good shape. If you open your mouth to this CID man, he is going to prosecute you. When you go down to see these people, if you do, sometimes we recommend it, sometimes we don't. You better know who it is in the world you're talking to. Bottom line, know who's there. If you're out here and if you have failed to file and this sort of thing, or maybe evading your taxes or things like that, you also better learn to do three things. Shut up, don't say anything, and be quiet. Because the man standing next to you in the assembly line might very well be an IRS informant. They pay IRS informants, folks. More people are being convicted by the man working alongside of them on the production line than they are from anything else because people can't keep their mouths shut. Remember, shut up, don't say anything, and be quiet. Because these people may have a tax problem, they may turn you in just to get relief from their own tax problem, but they will do it. This here now was written by another CPA, tax attorney in that. He's one of the major writers across the United States in regards to taxation and that. And he comes out with some very interesting things. He's the one that has now put the average taxation up to 36%, and he takes it from 31% to 36 when we had 24. I thought he was a little high on his estimation, but you know, he's entitled to his opinion on the thing. So anyway, the tax gap in this thing is that steadily across the United States they're finding more and more people that are not filing, don't want to pay, and they come up with all kinds of excuses not to pay, but they never decide they want to use the code. And this man here, what he's telling people here is to cut tax payments and put the government on a diet. That's what he's talking about. And he goes through several tax things in here that you can get a hold of and do, and to more or less avoid your taxes. But the best thing in this whole article here, it says our representatives ignore history when they assume they can collect more money simply by raising the tax rate. For some reason unknown to politicians, people don't work to pay taxes. It says people will work to avoid paying taxes, and if necessary will stop working to avoid paying taxes. And that's absolutely true. I know a lot of people that just simply walk away from jobs, businesses, and that because they're taxing them out of business, flat taxing them to go broke. If you have some time and if you want to really see a site down in Mexico, 15 miles below the border in Texas, California, and across those states, they have down there what is known as Little United States. You're going to see all major corporations in America that now have affiliations in Mexico down there. They've moved their corporate entity into Mexico. There's a book out now, the Japanese put it out, by the way, and it's banned, by the way, in America. You have to get it on the black market. And it tells you how to move your small business to Mexico and survive. Literally tells you how to do it. And they're trying, so anyway, a lot of things going on. Doug gave me this up in the room, and And I found it very unique because it clearly shows you in writing as to what Hillary Clinton, Bill Clinton's taxes are going to be. Here, you can see it kind of goes along here. This here was under Jimmy Carter. Here's where Ronald Reagan started it here real heavy. And then here's where George Bush came in. And down here, folks, almost off the paper, is Bill Clinton's tax bill, okay? Really amazing what these people are going to do. So anyway, here's another article that comes out, has to come out about tax season, and it says, put a lien on the Internal Revenue Service. And here's another tax lawyer that is bashing the IRS in the newspaper. 5 years ago, they would have never even thought about printing this thing. But through this thing, it says, to most Americans, the very mention of the Internal Revenue Service inspires fear akin to what the KGB used to instill in the Soviet Union. And with good reason. The General Accounting Office reports that 44% of penalties assessed against taxpayers for 1991 returns were in error. This is penalties and interest that they lay on you for they've got one out now, it's called a miscellaneous penalty. And when you ask them what this miscellaneous penalty is, they say, well, evidently you forgot to do something. They don't know what, but you forgot to do something. But anyway, I'll show you how we're getting around those things. And he says, nobody disputes the necessity of paying taxes, but this obligation should not be accompanied by intimidation, fear, and trembling. This is not a police state. Not a police state. Well, a lot of people will question that theory because right now what we're asking the law enforcement agencies all across the United States to do is to get involved in this. We got one IRS agent, they picked him up and jailed him for 24 hours in Omaha, Nebraska, because he seized the car and cannot produce his delegation of authority that authorized him to seize that car. Come to find out, he worked for a private collection company and had never worked for the Treasury Department at any time. We're finding this now to be very predominant across the Midwest because they came out openly, put it in the newspapers, that they were going to hire outside private collecting corporations to collect IRS tax bills. Your city here probably has one that collects parking meter tickets or whatever. Everybody uses them. But now the IRS is using them. And this is now running into a large problem for the Internal Revenue Service because they cannot delegate the authority to collect this thing out to a private corporation. Simply cannot do it. They must be an employee of the Treasury Department. So anyway, we're asking the police to get involved in this. We're asking the sheriffs to come and get involved in this. There's a program now that's starting in booklets that we're getting out to these people that started out of Phoenix, Arizona. It's called Vampire Killer. And we're getting this thing going across the country. The people that put this out are police officers. They go to the police academies and out and they talk to them that not to get involved in these things where there's laws being violated. We're seeing a tremendous change now in the way the local police and the local sheriff will no longer support the IRS agents unless they have absolute authority to be upon your property. Remember, there is no code anywhere that allows IRS agents to violate the law, state or federal. And we're hammering them on this issue. So what's happened here, now that there's a big rush going on right now, so to speak, to get the civil authorities involved in this, the federal government reacted to the thing, and they came out here, and we've seen these boys in training in action down in Phoenix, Arizona, and they're going to come out with their own police now to enforce the federal code. And there's a copy of their badge that they were wearing on their shoulder in Phoenix, Arizona. And there's a copy of it in color, okay? And we took this, the guy gave us the badge and took it right off his shoulder and gave it to us. And he was an Army captain. And they were practicing with their helicopters and everything out there in Phoenix, Arizona at that time. So anyway, we know this thing is coming. We know they're going to attempt to enforce these things upon us because the state and the local police and that are simply saying, no, we're not going to do it anymore. This is the book I was telling you about. It's called Vampire Killer. And I had some of these with me when I was in Ohio, and I've since ran out, and this is the only one I have with me. If you want one of these things, either get the address off the back of it and write to them, and I'll gladly send you as many as you want. If you want me to get them for you, let me know, okay? But throughout this thing, it talks about what they're doing, and there's Mr. McLamb's picture there. He's a police officer, ex-police officer right now, I think. But a lot of these statements in here have been verified, and that is what they have said, what the newspapers have quoted us as to being the power money people in America, who's running America, and why this taxation thing is getting out of control. So this is really good reading. If you want to get you know, I would suggest you get as many of these things as you can. Get them out to your local sheriff's office, local police agencies and that. Get them out to your local congressman. Say, we don't want this anymore. Right now, Congress, all of a sudden, is listening to the American people. And mainly they're listening to us because they know they're going to have to come and ask somebody to foot the bill for all this stuff. And the American people right now, if you followed the election down in Texas, they elected a Democratic senator down there, I think the first time since Texas came into the state, came as a state, and it was 2-to-1 vote. And what it was literally, a Republican senator, and it was literally a 2-to-1 vote against Clinton's tax policy. And Rush Limbaugh hit on this, several other people hit on it, that the American people are saying no more taxes. We can't pay what we have to pay now or what they want us to pay. They're taxing us into non-existence, putting our businesses out in the whole 9 yards. Here's another article. I don't know how many of your banks are in trouble back here. This one was printed out on the West Coast about the Bank of America. It literally says, grab your money and run. It isn't a question of them being broke, it's a question of when they're going to go down and take your money with them. So all these things are coming about. If you've been around some people, pilot connection and these sort of things, and I've several people have asked me about it, and I was going to show you this. This article here is out of Texas newspaper where they escorted them to the border and told them not to come back into the state of Texas again. California ran them out, they're over in Colorado right now. If you've been involved in one of these organizations, you're going to get a letter, hopefully it's going to look like this. It's going to tell you you've been identified as being a member of the Pilot Connection, ITT, and they want you to come down and talk. If you send in the 1040 NRs and that off the ADL, you're going to get a letter like this. It's just a matter of time until you get it. It isn't a question that you're going to get one, it's just when they get around to you. The CID is working real heavy right now in Seattle, and this letter here simply advises the man of his rights to remain silent. Remember, shut up, don't say anything, and be quiet. Because this lady is a special agent of the CID, and she is criminally investigating a whole lot of people involved in that operation right now. They'll normally come to your door, and they will give you your Miranda rights at the door, and then they'll follow it up. Okay, some other things going on right now across the country, and lawsuits and that on notices of levy and that I'll get into here a little bit later on. I want to share this one document with you because we've learned not to attack the IRS in a head-on position, but we've learned to go after the people that are in business with them. Corporations, banks that are simply giving away your money. We're going after these people, not after the IRS, but after the corporations that give away the money, especially if all they ever had was a notice of levy. And I'll show you that when we get on into this thing. Down in Los Angeles, this whole thing got started when Leland Hansen down there sued the bank for $69.12 because the bank gave the IRS his money, $69.12, because of a notice of levy. We found out some years ago that banks and most corporations have a 40-60 fee arrangement with the IRS. They keep 40, give 60 to the IRS, and the IRS promises not to audit them. That's the deal. And we've got this from ex-bankers, ex-IRS agents, the whole 9 yards. That's how it operates. So Leland sued him in small claims court. He sued the bank. He got mad. He had never been to court before in his life. He filled out the papers, put an affidavit in there with it, using a lot of information that I provided to him, and sued him. He then realized that he could win because the bank was asking the IRS for help, and the IRS was saying, we can't help you, you're on your own. So then he comes to me and he says, Ken, he said, I think I can beat these guys. How can I get more money? And I said, tell them that they violated or denied your rights of business and business esteem in the community were damaged, which is an actionable claim. So he upped it to the limit allowed in California small claims court, which is $5,000, and he got a judgment, $5,000 against the bank. The bank then appealed it through their attorneys and they knocked it down some, but he still beat them. So then following that thing up, we started some other small claims court actions, and Leland did this on his own. He just flat got mad. Matter of fact, the judge asked him in the court, he says, Mr. Hansen, this is only $69.12. Leland says, but it's mine, $69.12. And it's right, he just got mad. Here's a lady now, I had to scratch out the name on this because we had to sign a document not to tell people who did this, and I'll read it to you, or how much was settled for, all right? But this is the Bank of America. And this lady got mad because they took money out of her account, okay? And there's the debit form. We never signed anything that said we couldn't show you the debit form. This is where they debited her account for the money, okay? She sued, and then in an out-of-court settlement from the Assistant General Counsel of the Bank of America, they said, we don't want to fight over this. It says the offer of settlement is not an admission of liability which both, and now blank it out, and the bank specifically denied, but rather is an economic decision to avoid the time and expense which would be involved in fully litigating this matter. And it goes on, please note that the release contains restrictive covenants requiring that you keep this settlement amount confidential. All right? Well, when have you ever known a bank just go up and give you something? They don't do it, folks. They got sued. They knew they were going to lose. And they made a settlement and said, hey, we'll just give the money back. You go your ways and we'll go ours. So we've learned now to go into court on this thing. Right now I'm talking to the General Counsel of the Bank of America for the state of California, and it looks like they're going to simply stop honoring notices of levy from the Internal Revenue Service. This all started with the Mobil Oil case and the Beacon Oil case, which is what they have done. They said, don't send us your documentation anymore. You can't substantiate it. We're not getting involved. So now we're seeing major corporations. Matter of fact, we're after Montgomery Wards right now on this same issue and on the honoring of W-4s. We don't want W-4s anymore, and we've got a real good program on that right now. But through this thing, and through some very small things, like you go to a small claims court and get out a pre-made, it's typed in for you, you fill in the blanks and sue the burgers. Probably the simplest court in the country to operate in. And we're finding that people are readily doing this now, all across the country. They're just walking in and filling the papers out and say, hey, let's get on with it. And they're getting their money back. Simple as that. They're getting their money back. But anyway, all through this thing, and the basic fight against the Internal Revenue Service is exactly who they can tax, what kind of a tax can they put on us, all right? If you look at the restrictive requirements of the Constitution under Article 1, Section 8, there's only two types of taxes they can put on us. Only two. It's only been authorized. The 16th Amendment is a very narrow amendment. Whether it was passed, ratified, or whatever, I don't care. It's there. I'm going to use it. And I'm hammering the IRS with it right now to where the point to where the IRS is wishing it wasn't there too. Because it only allows them to do one thing, and that's it. And that's put a tax on the income. That's all. That's all that thing allows those people to do. And I'll show it to you. And I'll show you how you can use it against them. But anyway, we're in a letter writing campaign right now with congressmen, senators, and people all across the country are doing this. You're going to be surprised at what these congressmen are going to write back to you. This one here happens to be from Hawaii, and what happens here, let me explain this to you. Congress does so many stupid things they can't keep track of it, all right? But there are people in what is known as the Congressional Research Service that do. They keep track of it, and when they want to know what stupid thing they did, they retain the American Bar Association lawyers from the Congressional Research Service, and they research this specific item, all right? So what they wanted to know was exactly who did Congress make liable for paying the income tax. Now, there's two aspects here, and this is what a lot of people get confused on this, and I'm going to hammer this into you before we go out of here today. When you're fighting the IRS, there's two aspects you fight. Are you required to file, and are you required to pay? You may be required to file, you may not be required to pay. You may be required to pay, whereas you may not be required to file. There's two fights here, folks. You got to understand them, or you're going to get yourself in trouble. So anyway, what Congress wanted to know was who is required to pay the income tax or the tax on the income. So they hired the Congressional Research Service to put out a pamphlet on the research as to who they made liable for this thing. And it says, based on the research performed by the Congressional Research Service, there is no provision which specifically and unequivocally requires an individual to pay income taxes. That's what they found, all right? We took this thing and worked it over and worked it over. I don't have the whole thing. I've never been able to get my hands on the entire document. But based upon those theories, there is what Dick Stein used in the case United States versus Sanders in Tennessee when 17 people walked out of all those charges down there. Because he hammered to the IRS tax expert He said, show me what specific section of the code requires these people to pay a tax. After 3 days of cross-examination, he finally admitted there is no section of the code that requires this. They were found not guilty. They walked. A whole bunch of them. So anyway, based upon that theory and that concept, we started after the IRS, forcing them to obey the law. Very subtle approach to these people. You never want to get yourself into a position of being called a tax protester. You never use theories, opinions, you never make statements, you never demand things from them. You simply go into a very, very low-key, subtle approach. In other words, kind of dummy up, you know, and ask stupid questions. You're going to be surprised because they'll start answering you. When the Bodwells in Sacramento sued the IRS down there, and they've a long time they've been in this around. If I don't know these tax scam artists out there, Ron does. All right, we get together and discuss a lot of things going on. But when Ron sued them, they had the IRS agent on the stand, and they started asking him some pointed questions, all right, as to who's liable, what section of the code. And the IRS agent is telling them, I mean, he can't keep his mouth shut. He can't do the three things, and that's shut up, be quiet, and don't say anything. He's telling them the whole 9 yards. And the judge is banging his gavel trying to shut this fool up. And finally the judge says, shut up, you've told him too much already. Literally, all right? Because the guy couldn't keep quiet. He was simply, they were asking, you know, questions, he was giving them the answers. So anyway, we've learned how to do this thing and how to operate it. And now I'm going to show you the infamous 16th Amendment. And like I say, you know, you can argue whether it was ratified or not. Probably show you good documentation in support that it wasn't. And all that sort of thing. The courts are going to just simply not listen to it. The administrative agencies won't listen to it. They'll tell you that is a political question, and let it go on from that. And I said, all right. My position in this is that if there's a law out there that the IRS can use, there's a law out there that I can use. There's somewhere on that law a place for me. And that's what I've learned to do. That's what the Paul Shrett told him. And he said the only thing wrong with what he does is he wants us to obey the law as well. And this is scaring them because if they have to obey the law, they can't collect the tax. So anyway, there it is. 3 sentences, all that thing is, all right? You read that. Can you see that in the back of the room? You can't see it? Okay. You read it. All right, it says here, the Congress shall have power to lay and collect taxes on income from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Did I say anything up there about a citizen of the United States being taxed? How about a citizen of Massachusetts? I didn't read that either, did I? Well, I'll be doggone. I wonder why that is. Do you have any idea? Do you have the slightest inkling that maybe it doesn't include you? Where did we ever give them the authority to tax a citizen of the United States? Well, I'm going to show you. I'm going to show it to you in the rest of the IRS code in their own definition that Congress made up. All right? But that's the only thing we've ever given them. The only thing that is not covered by Article 1, Section 8, which is the taxing authority of the government, the only thing that's not covered in there is tax on income. Tax on income. Not an income tax. You know, if you want to learn, see, I probably failed English. But my only requirement going to school was that I not snore in class. All right? Because I could take this little thing they call the pigskin and I could do a lot of things with it. All right? So just don't snore and show up. All right? So when I want to learn about the English language, I have an English professor that I write to and I ask him. I said, what is a tax on incomes as opposed to income taxes? And right, matter of fact, you got an English professor on there asking. 2 entirely different things, right? But anyway, if it's not a tax on the income, it must be apportioned among the several states, and it must be in regards to census or enumeration. In other words, it's equal pursuant to the census of that state. That's all. Now, is a tax on income, does that include penalties, interest, and this sort of thing that the federal government's charging you? How about that miscellaneous penalty? Oh, doggone. See, if that's not a tax on the income, wouldn't it then fall back under Article 1, Section 8 that had to be apportioned among the several states with regard to census and enumeration? Ask the IRS about it, see how long it takes them to get off your interest and penalties. Interest and penalties is nothing more than a form of taxation. That's all it is. It's another tax under the guise of being something else. But if you read and research the courts and what the courts have said on this thing, it's a tax. It is nothing more than a tax levied by the federal government. Nothing more than that. Hammer them with it. If you don't believe me, write to them and ask them. Very subtle approach to them. So anyway, that's the infamous 16th Amendment. Right now, this is the booklet that the IRS is sending out across the United States as to who they want to collect this tax on income from. And they put it out in writing, right? All through this thing, they're making reference to what is known as a U.S. citizen. A U.S. citizen. Well, I don't know if that means United Steel or what. Maybe you know. Right next to Congress, when they ever authorized this U.S. citizen taxation. Matter of fact, look in the Revenue Service Code and see if you can find that term in there. Because I can tell you right now, it isn't there. So simply write and ask them. That's what we're doing. The major approach we're doing to the IRS is saying, hey, this isn't me. Do you have any reference in your code or your computer that this belongs to me? Or that I'm under this title? Pretty soon you start getting letters back. Pretty soon, like the people up in Idaho. They were getting a letter a day from the IRS. At least every other day, the collection agency was out hammering on their door. They got involved with me. We put in some very subtle letters. They never seen the IRS for 2 or 3 weeks before they called me. All of a sudden, all the letters stopped. So he calls me up and he says, "What's going on? I'm really worried I'm not hearing from the IRS anymore." And I said, "Well, isn't that great?" I said, "They've been to your house every week. They've been sending you letters every day. And now all of a sudden, when you get something in that they understand, they don't come around anymore." He kind of paused on the phone and he says, "My gosh," he says, "maybe we're on the right track." Well, anyway, the thing that you've got to understand in this taxing thing is who can be taxed, who can't be taxed, and how they make the determination that you are a taxpayer. Remember now, you've got to understand this very clearly. You know, we're going to stay here till midnight. Because I'm going to ask questions here on this now as we get going. You've got to understand two things. There is a requirement to pay, and there is a requirement to file. You may be required to do one. You may not be required to do either one. But you must understand it so that when you talk to the IRS, you can clearly determine what it is you're talking about. In other words, don't get yourself involved in the Peter Principle. And if you don't know what that is, Peter Principle is one level above your incompetency. You're way up here. You're out of your league, more to speak. But anyway, here, this is an old case. It's a 1974 case. And even you can research it back further than that. This is the case here of Mrs. Morrison and that. Mrs. Morrison did not file a return. A third party filed a return for her. The minute a return is filed, you become liable for a tax. Whether it be legitimate or otherwise, you're liable for it. Then it's up to you to show the IRS that you are not liable for it. This is where the courts come down on you and say, you should have done something. You should have done something. Because they've already made the determination that you are a taxpayer and they filed a return for you. The secretary or the commissioner, anybody, will file what is known as a substitute return. Let's say if you sent them in a 1040, they didn't like the figures in that 1040. They will zero out your return and the secretary will make a substitute return for you, clearly in the code. When he makes that substitute return, he makes you a taxpayer because he filed a return in your name. Okay? That's what he did. If you didn't file a return, he will make what is known as a dummy return. And that's covered under the code. That's how they get you hooked in to being liable for paying. Not for filing now. We're not talking about filing. Don't get these two mixed up. This has to do with paying. Because the taxpayer is the only one that is liable for the payment of the tax. All right? This is where it starts, right here. Somebody filed a return in your name, all right? Now, through this thing, when you start getting involved in it, now them papers aren't going to fit there, and I'm going to have them all over the floor. There, here we go. Now, I'll show you this thing as to how they get you into this, because this is their own definition of a taxpayer. Right here. The term taxpayer means any person subject to any internal revenue tax. The only way you can be subject to any internal revenue tax is that somebody has filed a return. Somebody has filed a return. Now, there's several arguments that you can make off of that thing. Because Section 6065 of the Code requires that all returns be verified. Section 6061 requires that all returns be signed. When we've asked the Secretary, the District Directors, and the Delegation of Authority to make these returns, we say, where is the verification for it to be a legitimate return? They tell us, we're not signing that thing under penalties of perjury. And I say, why not? Don't you want the liability? And they will flat tell you, no, they don't. When we go about getting the release of a levy, as a matter of fact, Dave and them, when they got the release of a levy down there, right on the back of it, the IRS immediately wants you to sign away your right to sue them for damages. Isn't that right? They want you to sign this away. We've seen it time and time again. And when you refuse to sign it, they'll sign it themselves, trying to relieve themselves from the liability. Now, I don't know, maybe I'm not thinking straight, all right? But if they want a release from liability, did they have a liability? I mean, that's like Nixon said, I didn't do anything wrong, but give me immunity anyway. Well, why did he need immunity if he didn't do anything wrong? If they want release from liability, surely they must have done something wrong. But they'll sign it themselves, folks. So we're saying, wait a minute, this is crazy. You know? So we're telling people, don't sign them. As a matter of fact, if you want to revoke your Social Security number, you can write to the Social Security Administration. This is the only way you can do this, by the way, is write to the Social Security Administration and get an application and a request to revoke your Social Security number. All right? It's the only way that's recognized by them. But right in this thing, you have to sign away your rights to sue them for fraud. Now, I have to say, I'm not very intelligent, you know, and granted, I may not have the schooling of some of you people, but when they want a release from fraud, folks, that tells me they did some fraud somewhere. It only stands to reason that they did it. So anyway, nobody wants to sign this stuff under penalties of perjury, but they want you to do it, all right? They want you to sign under penalties of perjury. We're saying, wait a minute, doesn't that apply to you as well? One agent told me, he says, not so far. And I said, well, it is going to be now. Document after document after document that we're getting now from the IRS for our client, we're shipping it straight back to the IRS and saying, would you please sign this and verify it pursuant to 6061, 6065, so that we know who to file criminal charges against. Did you know that it's theft under the Uniform Penal Code laws in any state to take money from anybody under fraud and pretense? It's called theft. 18 United States Code 1001 states that if you sign your name, put down any false information on a official government form within a jurisdiction of any government agency, it's a felony. So now you know why these people won't sign these things. Because they're putting information down there that they know is not true. We always put in a copy of the code of theft and 18 United States Code 1001, and we ship the document back to them and say, please sign here so we know who to have arrested. All of a sudden, it's like you haven't bathed for a while. You don't want to come around. The man in Idaho says, I'm nervous, Kenny, because they're coming here every week. Now they're not coming out here anymore. He didn't know what to do. Complete reversal. See? So anyway, when I got started into this thing, and signing these silly forms and that they want you to do, I come up with some interesting things that I'm talking to Congress about and several other people about. I've showed this to some major corporations across the United States, and now all of a sudden, they're getting involved in this program, and they're saying, hey, wait a minute, do we? Well, let's take this thing, and these are the infamous forms they want you to sign every April, right? There's 1, 2, 3, 4 of them. That's the basic forms they have, right? They don't have anything else. These are the 4 forms right here, right? So we go up here to the infamous 1040, which says U.S. individual income tax return, right? Now, I didn't make this up, Congress did, or the Secretary, or somebody did. Does anybody know what a U.S. individual is? Well, see, well, you're right with the IRS, because when you ask them, they'll say they don't know either. The basic thing that they tell us when we start asking them questions like this is sign the thing and send us your money. That's all they know. I've showed this to the Gary Allen in Ben Franklin Station, Assistant U.S. Attorney. Matter of fact, under oath, we asked him what the term U.S. stood for. And he says, well, he says, in my opinion, it means United States. But he said, I could be wrong, and I probably am, because it's not defined in the Revenue Code. Now, do you know what the Internal Revenue Service can enforce? Have you ever looked at their enforcement? It's only to enforce the Revenue Code. They have no authority outside the Revenue Code. Now, if this is not in the Revenue Code, do they have the right to enforce it? Of course not. They've never been delegated that authority. They cannot come outside that Revenue Code. And when they do, you can nail them. The Supreme Court says we can nail them down individually and personally outside the agency for any damage done not covered under color of law. So when you sign this thing, if you sign it blank, you're committing perjury. Because you're swearing to be a U.S. individual when you don't even know what it means. So why don't you simply ask them for a form for a citizen of the United States? As a matter of fact, if they had the right to tax a citizen of the United States, why in the world doesn't it say that? Ask your congressman why it doesn't say that. I'll show you in a minute why it doesn't say it. But write and ask these people. Don't take my word for it. Get after them. Let's see some answers to some of this stuff. So anyway, this one here has to do with trust. This one here has to do with U.S. partnership return of income. Do you know what a U.S. partnership is? Well, hey, that's real good, because it is impossible to have a United States if that's what that means. Partnership. Because the government simply doesn't create partnerships. They have no authority to create a partnership. This next one down here, I showed you some major corporations in America. Sit down with their counsel and talk with them. I showed this to one major corporation in California that was about to go broke because they couldn't pay their taxes clean back from 1988. They've been dodging them on extensions and this, extensions on that, on 940, 941, and 1120s. This is an 1120 form here. When I sat down and showed them, I said, do you know what a U.S. corporation is? And they said, well, we assumed it was us. And I said, well, I don't know if U.S. means us or not. But I said, did the federal Congress create this corporation? And they said, absolutely not. I said, who did? They said, the state of Nevada. Wait a minute, he said. Because you could see this lawyer was trying to think, because his eyes was kind of clicking to brown, you know. And he was going, well, and he says, wait a minute. He said, that's not the form that applies to us. And I said, no, you've been telling your client to commit perjury every April by claiming to be a U.S. corporation. Do you have a federal charter? No, he says, we have a state charter. He says, wait a minute. They can't tax us. He says, we're an arm of the state. Another argument, folks. State corporations are born by state law. They can be killed by state law. They operate by state law. So are they the state? Yeah, absolutely. Absolutely. And we're making that argument with them right now. On this major corporation, in 30 days, I tax abated all 941 taxes and 1120 taxes. In 30 days, the IRS recognized that this corporation was not liable for paying. They cut me a check right there and I was out the door smiling. Real quick. But anyway, through this thing, you must understand what it is you're arguing about. Now, we're not arguing about paying here. This is a section having to do with filing. Only filing, all right? So anyway, this thing here, like I say, it's loaded dynamite right now as to what the thing means, the whole 9 yards, and I'll show this to you. I got sections of the code up here that I want to point out to you, and I'll point this one out to you right now. If you go, this one, the determination and definitions of a person, you're going to find the 7701A1, and I'm going to go through that and I'll come back to it. In advertising, if you look into a magazine, upper right-hand corner of all magazines of prime advertising space, you'll read that section. You'll retain probably 60% of what you see in the upper right-hand corner. All right? Ask any advertising agent, I'll tell you. The rest of the page you go through and retain maybe 20% of it. All right? That's about all you're going to retain. So this definition here, they wanted first. 7701 is the first definition you're going to come to. 99% of the American people will never read past that section. That's where it'll end, right there. But if you go 4 sections down, you find these 4 sentences, okay? You find these 4. And it's 7701A4. And it says the term domestic, when applied to a corporation or partnership, means they created or organized in the United States or under the law of the United States or of any state. Okay? So what this tells you here is, and the courts have agreed, that when they're talking about a corporation created in the state of Massachusetts, they must use the term domestic corporation. All right? Domestic corporation. Do you see domestic there? You see it? It isn't there, is it? So what in the world are they talking about? Well, and their own code requires them to do this. Okay? Their own code. So then you go back up here to 7701A1, it says the term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. All right? Did you see domestic, or did you hear me use the term domestic in that definition? Not there, is supposed. So then what is this corporation? It has to be this one, doesn't it? Has to be. Ask Congress. Ask your IRS agents when they talk to you about it. They don't use the term domestic corporation, and they do not use the term domestic partnership in the first definition. And I'm going to show this to you again here as we get on through this thing. But anyway, through all this thing, you're going to find out, and I'll show it to you, the filing requirement only is up on a corporation, here. And it's only upon an individual, here. Because you'll only find the definition of individual in that section right there. It's the only place you're ever going to find it, right? Now, an interesting thing happens here. When you read over about 3 more pages, you come to 7701A30, which is this one right here, all right? Basically, there's 4 lines, 5 lines in this section of the code. In here, they define as a United States person, a citizen of the United States, domestic partnership, domestic corporation, and any estate or trust. All right? Now, here they knew to put domestic corporation. You don't see domestic corporation here. You see it here. You don't see it here, but you see it here. Okay? Now, in these 4 lines, A, B, C, and D, do you see the term individual in there anywhere? It isn't there, is it? Well, I'll be doggone. Wonder why they left that out of there. Wonder why they left individual out of the section that defines a citizen of the United States. Or I'll be doggone. Well, anyway, let's get on with this thing. All through the taxation that Congress has done, clean back before the 16th Amendment, clean back before the infamous Bruce case and all that, They have always defined in all their taxation and distinguished between the term person as opposed to citizen of the United States. They've always defined that. And they've always separated it out. And the reason they separated it out is a real old Supreme Court case that has to do with what is known as the Congressional Dictionary Act. When you come to a statute, folks, don't pull out Black's Law dictionaries, Bouvier's, or any of this other stuff. Congress doesn't use them. The courts very rarely use them. They use what is known as the Congressional Dictionary Act. And you'll find that brought forth in the Wills case, Wills versus State of Michigan Police in 1989. And they'll give you the statutes and the ranges there as to how far that thing goes back. Congress wants to know specifically what that term means when they put it in the code. So they knew from the Dictionary Act the term opposed, as opposed to citizen of the United States and person was opposite, because the Fox case literally stated that a sovereign cannot be bound under a statute by the term person or any person. If you read through the case laws on who is the sovereign in this country, you'll find out the people are, and we are still recognized as being sovereign. The courts will still uphold it, have upheld it, and will continue to uphold it. They upheld this sovereignty issue in as late as 1989 in the Wills case, when they said no sovereign can be bound to a statute under the term person or any person. He must be specifically named. We're hitting them with this now. We're saying, where did we ever give up our sovereign rights to be named as a person or any person? And boy, if you want to see them run, just bring up that issue. They don't even want to touch it. 3 judges recused themselves, which means they excused themselves from the bench in the Bodwell case when we raised that issue in Sacramento. They did not want to hear it. They finally got this retired senile judge to come in, and he ruled on the case and said basically what he was saying: take your argument to the next highest court, which we are doing so right now. And that's pretty much what we wanted him to do. Just make a ruling. We don't really care whether it's stupid, right, or wrong. We just want to get on with it. Let's get up into the higher courts and see what they have to say about this thing. Now, we don't recommend that everybody go out here and file lawsuits. You're going to lose. Do your homework and talk to these people administratively. But do your homework on this thing. How many of you in here have ever heard about Kermit the Worm Man? Oh, new story. Ah, okay. I'll tell you this little funny story. Kermit is a man, he was well-dressed and that. He didn't believe in having licenses of any sort. But he researched his issues and he knew what he was getting involved in. He was fishing in Yellowstone National Park in a creek, right? The federal game warden comes up and he says, "What are you fishing with?" Kermit said, "I'm fishing with a worm." Well, if you've ever fished up there, you can't fish with worms. You have to use flies, right? So the Fish and Game says, "That's a fly fishing creek." And Kermit says, "I couldn't catch any flies, so I didn't use a worm." The guy puts on his waders, wades out in the creek, and gives him a $50 citation. Which if you've ever fished in Yellowstone, you're going to get a $50 citation, right? That's just common practice. They put every senile judge in the federal system, or at least pick out the worst one, and they put him in Cheyenne to collect this $50 ticket, all right? Well, Kermit, in the meantime, Kermit didn't have a license on his Toyota pickup, so they towed it off of Yellowstone and dropped it at the boundaries of the Yellowstone, and they ticketed it, and the citation on the windshield was that it was a defective airplane part, okay? So anyway, Kermit wanted to fight this thing for $50, right? So it comes time to appear. Kermit lives in Seattle. So we all go to Cheyenne. We get out to Cheyenne to see this big show, and there's no assistant U.S. attorney. So the judge there, he stutters and stammers and says, "Well, Mr. Hawkins, you don't understand." He said, "You were just supposed to pay your $50, not show up." Kermit says, "But I'm here for trial." And the judge says, "Well, the government's not ready for trial." Kermit says, "You better get ready because I am." So the judge says, "Well, I'm going to take a recess." Well, everybody knew what he was going to do. So he goes down, he gets this assistant U.S. attorney, and they're riding back up on the elevator together, and they make a deal to get a postponement, which means we go back to Seattle. Kermit pays us $50 the last time they hear from us. Wrong. That's what happened. They got a deal. They got it extended. So when we got back to Seattle, we entered 100 and some odd motions into this court. All right? It hit the national news, by the way, that we were taking over the court by compelling the court to obey the law. We had motions to hear it. The biggest one that got the biggest write-up of any of them was that Kermit wanted to see the corpus delicti, the body of the crime, which was the worm. Right? That was the worm. Well, the agent didn't keep the worm. Right? So the assistant U.S. attorney, he got into the act, and he wrote back and said, we lost the corpus delicti because a robin ate it. Look, I'm telling you, this is a true story. So we petitioned for a roundup of all robins in the Cheyenne area to extract the body of the crime, and we wanted U.S. Marshals to protect the body of the crime until we could get there to view it, to see if it was the worm that Kermit was using. This thing made international news. Past news agency picked up on it and said, see how free Americans are? They can't even fish in a creek with a worm. Kermit was on every talk show, the Johnny Carson, all of them, he was on there talking about this silly worm, right? And well, the old judge, they finally forced him into retirement. But as it turned out, they raised the fine to something like $5,000 and sentenced him to 2 years in prison over this worm. The appellate court threw the whole thing out, so we're going to have nothing to do with this, and tossed the whole 9 yards out. But simply because the guy understood what he was doing and researched it, the newspapers claimed he made a mockery of the federal court. Literally, because they had no idea how to obey their own code. They had never seen it before. Nobody had ever enforced that on them. When we were over there, we couldn't buy food. The Holiday Inn put us up. We had a rented car. People would, hey, there goes those worm guys. Hey, hey, hey. Because everybody gets hit with a lousy $50 worm ticket. Well, they've changed their policy right now on that $50 worm ticket because the government admitted that in the Kermit Hogan case, would you like to take a guess how much they spent? It was on the Johnny Carson show. $275,000 to collect how much? 50 bucks. And then you wonder where your money goes. So anyway, if you can imagine when that thing was on the Carson tore him up. I mean, he tore him up badly. So anyway, I'm going to show you now some real fast definitions here. Getting on down with this thing. Maybe you can see these a little clearer. This has to do with that 7701A definition of the term person. Here's a little bigger. Can you guys see it in the back of the room yet? It says the term person shall be construed to mean an included individual, a trust, a state, partnership, association, company, corporation. This thing here is the photocopy and the transparency of the actual code. Here's another one of the actual code that defines who a citizen of the United States is, the whole 9 yards. Here is where they use the domestic corporation, and here is where they define a citizen of the United States, and you will not find the term individual anywhere in there. You will not find it in there. Yet if you look at the code, and the requirements of the code as to who is authorized to file, and who has to file, and who doesn't have to file, the filing requirement always falls upon the individual. Always files. So anyway, in this thing, and in the research of it, we have found out several things. One, we found in concerning Article 1, Section 8, and that we found an article that was written by a committee from the Attorney General's office, which is the highest law enforcer in our land. Janet Reno is in there now. Whether you care for her or not is really irrelevant. But anyway, there's the first page of it when the thing came down. And what this has to do with is taxation. And this, again, is back on the things like that, right? Payment of taxes not covered. Do you see it there? It isn't there, is it? See you shaking your head? No. It isn't there, is it? I didn't do this. This is, I just read, If the individual is required to file, If it is the individual required to buy them, why in the world didn't they put the term individual in that section of the code when they defined a citizen of the United States? Are you starting maybe to see that we never authorized them to tax a citizen of the United States? And we never did. We never gave them the authority. The 16th Amendment never gave them the authority. It only said a tax on the income. Are you defined as income? Nah. No way in the world. No way in the world, folks. And when you start getting after them on this thing, I'll tell you, it's kind of like the difference between night and day. They get to looking at you like, hey, there's easier pickings down the road. Let's go down the road and get away from this guy. And this has to do with your 940, 941 taxes. And the main sentence you're interested in is right in here. For the delegation to the Secretary of Treasury to assess and collect any deficiency. However, the Internal Revenue Service does not have authority to collect the 940 or 941 tax, since these are California state taxes. You'll find that they're also the same in the state of Massachusetts. Right? They've never had that authority. It's simple, total, they've never had it. And these are letters that we write to Congress and get. We're asking them right now about the 1040, where they put us into this thing, how we got into it. We want to know why these taxes are out here being assessed. Literally, we want to know why the law isn't being obeyed. One of the main things that I used in fighting traffic citations was I wanted everybody to obey the law. That's where I got onto this kick. And every time I bring this, it didn't matter whether they wrote it for no driver's license, speeding, or whatever it was. My main argument was that it was selective prosecution. And if you start raising the issue on these citations out here concerning selective prosecution, you're going to see some interesting things happen, like the judge is going to start banging the gavel. In Snohomish County, Washington, the Superior Court judge up there issued an order for the Washington State Patrol not to ever bring me back in that courtroom again. Period. They simply did not want me there. And what I was using at that particular time was, that was when the 55-mile-an-hour speed limit was out. The law violation was at 56. At 56 miles an hour, you were in just as much guilty as 85. When I had the officer on the stand, I asked him, I said, when do you write the citation? He said, it's 60. And I said, oh, wait a minute. I said, isn't that selective prosecution? Boy, the judge started banging the gavel, because he must arrest him at 56. He has no authority to allow you to do 60. Has none. So now you come back to discrimination. Is he picking on your red sports car? You know, different things like this. And you can have a lot of fun with this once you get down and get everybody to obeying a doggone law on this thing. They brought me into a traffic citation case in a town in Arkansas. And when I got in there, the first thing I wanted to do was to find out if the city police had the authority to enforce the state motor vehicle code. Come to find out, not only didn't they have the authority to enforce the vehicle code, there was no city. All this was a bunch of factory houses built up around a chicken plucking factory down there. And they went from security guards to started calling themselves city police. They had no authority whatsoever. I was brought into another case in Nebraska, and the thing I wanted to do there was to find out if the Nebraska State Patrol had ever been authorized to issue a ticket out of the motor vehicle code. And guess what? They never had been. They started throwing tickets out of court up there left and right because nobody had the delegation of authority to issue one. When we started researching in Michigan as to who had the authority to issue a fish and game citation up there, you know what we found? 2 people. The governor and the assistant. That's all. They never delegated it to anybody else. So when you start getting involved in these things, find out who in the world it is you're talking to. You want to know if he has the authority to do what he wants to do. In a lot of cases, you're going to find they don't have it. They simply do not have it. And this applies in everything that goes on in state and federal, county, and city government. The delegation of authority starts from the top, and it must come down. And if they do not have a specific chain of delegation of authority, somebody's in big trouble. The man up in the claims to work for the IRS in Omaha, he cannot prove that delegation of authority because it must be specific. He doesn't have it. he's been given 30 days to produce it, or they're going to file auto theft charges against him. Simple as that. So anyway, through this thing, I'm going to show you some more stuff now. This is an actual court case. It's an ongoing court case still yet today. They've made some very interesting revisions in this case. We have about 100 of these going across the country right now. Mostly we want to talk to them at the administrative level. But sometimes you can't. If you're going to try to get a house back, if you're going to try to get something that they already have their hands on, you're going to have to sue them. They're not going to give it back to you administratively, or at least anyway we haven't ever seen them give it back administratively. So that comes time in for the courts. You must take them into the court system. And you must understand what it is you're doing when you get down there. You're going to get beat over the head. You're going to get beat real bad. If you stay on point with the argument and that, you're going to win. Because you have the law on your side. And when you have that law on your side, you make an issue of it. And you continue to push these people outside what is known as public policy. The biggest thing going for the IRS right now is summonses for books and records. They want to see books and records, all right? You can have a lot of fun with these things, all right? If they're sending you out a 2039 summons, this came right here from the Assistant U.S. Attorney, Ben Franklin Station, and you might ask yourself why I talk to all these people, all right? I have clients who retain my services to make deals with the IRS, to go in and talk to them, change their filing status or whatever, to get them, so I don't want an offer and compromise situation made out in that, so I have to go talk to them. You can say you're not liable for filing. I can stand up here and say you're not liable for filing. But until the IRS says you're not liable for filing, you've got a problem. So when you retain my services to go do this, that's what I go do. I cannot go and talk to you or talk to another tax paralegal out here, because that doesn't matter either. You must talk to the IRS, and you open up a rapport with them, and you learn how to talk their language. So when I was down in Washington, D.C. talking with some of these people, and I asked him specifically about a 2039 summons, which is real heavy on the West Coast. He says, well, Ken, we made that obsolete years ago in 1984. And he gave me this paper here. Not only did they make it obsolete, they removed the delegation of authority for the Secretary to use the form. So if you're getting hit with these things, this is what you want to hit them back with. Say, excuse me, this is what I have. Do you have something different? You know? Make them obey the law. Even in these summons issues, make them obey the law. In one deal out in Nebraska that I got tied up in, I had a guy call me up, and he says, Ken, he said, you got to get out here right away. I said, I can't make it. He says, you got to come right now. He said, I need help now. And I said, no, I said, I don't have time. I said, I just don't have time. And he says, I need you now. He says, understand me, I need you now. And I said, well, okay. I said, go ahead and get my plane ticket and that, and I'll be there. He said, it's already down there, just go pick it up and get on the plane. So I flew out, and this is a big motel hotel complex. So I get out there, and the guy starts showing me his books. He's got 5 sets of books. And I said, you go to prison for this. He said, that's the reason you're here. They're after me. So we stayed up all night, and we cleaned his books up. I got on the airplane back to the West Coast. When I got off the airplane, they had arrested him already. So I got on the plane, I flew back out there. I asserted myself into the case in the whole 9 yards, and they started asking me for books and records, right? Now I know the IRS people out there, and I know the judge, and I know the assistant attorneys. So I said, define books and records. I said, you mean you know about Look, about U.S. Weekly? You know, no, he says, you know what books and records we want. And I said, no, I don't know. He said, Ken, he says, you know what we want. And I said, no, I don't know. We went through this all day, and he says, well, he said, I can see, this is the IRS man, he said, I can see that, well, he said, we really need you to hang around out here to get this straightened out. I already got the guy out of jail, all right? He said, we really need to have you hang around out here for a few days till we get this straightened out. And I said, at whose expense? Well, he said, I guess the government could pay. Well, I stayed in the best room they had there. Taxpayers' expense, thank you. 5 days, right? So the 4th day, we're still arguing over books and records. And I'm still saying, I don't know. Tell me what you want to see. As a matter of fact, if you write to the IRS and ask them to see something, and they don't want you to see it, they'll write back to you and they'll say specifically describe it, because we don't know what you're talking about. That's where I learned to do this. I said, if they can do it, I can do it. So anyway, I said specifically define books and records. Specifically define bank deposits. What do you mean by deposits, you know? So anyway, they made the mistake of saying, well, we'll just have to go in front of Judge Urbaum and get this settled. And I said, you bet, let's go in front of Judge Urbaum and get it settled. The 5th day, Friday, we're in front of Judge Urbaum. The assistant U.S. attorney and the IRS agent, they start right off by saying that I am refusing to cooperate. And I said, now wait a minute. If you're going to lie, I'll tell the story. So they shut up and I told the judge. I said, Your Honor, all I'm asking them to do is specifically define what they want to see. The judge says, well, there's nothing wrong with that request. Define. Define what you want. But what the IRS agent was trying to tell the judge and couldn't get it out was that he knew that if he specifically defined what he wanted to see and it benefited me, I would create it. I have a tremendous computer system. And I can create IRS documents better than the IRS can. So this is what he's trying to convey to the judge. That if he specifically defines it, I'll create it if I don't have it. So he's saying, Your Honor, if I specifically define what I want to see from Mr. Hunter, I'm sure he'll have it. I'm going, that's right. That's what I'm saying. If he'll just define it, I'll look to see if I have it. Maybe I have it, maybe I don't. But I don't know what it is he wants to see. The judge is saying, just define it so Mr. Hunter can see if he can produce it. The guy's going to say, but Your Honor, if we define it, I'm certain Mr. Hunter will have it. And I'm going, that's what I'm saying. Just define it. And I'm certain I'll have it. Noontime come, they didn't want to talk to me anymore. We didn't even get any of the basic arguments on this defense. They couldn't get past the first one. So why go to something else? I didn't even have to use production use immunity. I didn't even have to use the Fifth Amendment because they can't get over the first argument. So why go to something different? When you get these guys on a stump, hold them there until they get over the hump. Don't give them something new to chew on. Make them address the first issue. They couldn't define what they wanted to see. Flat could not define it. So anyway, in a case down here in Virginia, Mail versus the United States, Johnny is a tax protester. He is a protester of anything. Okay? No driver's license, no automobile tabs. He spends a number of days in jail. Okay? But he had been in prison before for willful failure to file an income tax evasion, I think was the two. And he didn't want to go back again. And they were after his books and records. So anyway, he has tried everything in the world. I mean, if it sounds, I think he would have tried jumping off the pier. Did that ever hit out here? You ever hear that one? This guy calls me up one day and he says, Kenny, he said, I got the perfect solution to the tax problem. He says, I'm going to get this ordained minister, and he's going to be with me. I'm going to run out the end of this pier, and I'm going to submerge myself in water. He's going to proclaim me drowned. I'm going to walk out, swim out, or whatever. He's going to proclaim me reborn, and I don't have to pay taxes anymore. I said, get out of here. Well, I kind of think Johnny would have tried that, okay? He's tried everything in the world, all right, to do this. But he knew he didn't want to go back to jail again, so we had to stop him from getting books and records. So they were after him with two summonses, 6638 summonses, which are legitimate summons. But there's ways around them, but they do have the right to use the 6638, providing they have a taxpayer. That's the key word, taxpayer. If they ever get over the hump of the term taxpayer, which they have never done in all the years I've been at this, then you hit them with Fifth Amendment production use immunity and Fifth Amendment rights of expression. All right? So anyway, we challenged in a lawsuit back against the two summonses. Count 1 and count 3 had to do with the two summonses. Count 2 had to do with quiet title on this property. We put in such a argument on the Fifth Amendment production use immunity that the government withdrew the summonses. flat withdrew them and notified the court that we're not going to enforce them at all. We joined them in a motion to dismiss count 1 and 3, and it says here, as defendant, meaning the United States, has advised this court that the IRS will not move a United States District Court to enforce the summonses, which is what we wanted to do. We flat stopped them with production use immunity and rights to first expression. The courts have linked anything going to the IRS that you say, utter, speak, or express that can be linked to a criminal prosecution, you do not have to do. You do not have to produce any document that would lead to a chain of events that might subject you to criminal prosecution. You do not have to do it. I guarantee you right now that if the IRS summons your books and records, they are after you criminally. The courts have all along and well established this, that when they come for you and any of this stuff, they're wanting documents to prosecute you. You have these rights. So if they get past your first argument, fall back on the Fifth Amendment, they can't get around it. Every court is upholding this. Upholding it down to the point that where even if the Bodwells now have been ordered to appear at a hearing to produce expressions and books and records. They don't know what they're supposed to produce, but they were ordered there by the judge. When they got down there, they took Fifth Amendment production use immunity. And the way it works is they ask you a question and you take the Fifth Amendment, because you have no blanket Fifth Amendment rights. So the minute they ask the question, they define the document or whatever, you take the Fifth Amendment. What happens then is they're then faced with taking you in front of a judge and compelling you to give the answer, which the judge won't do because he can't violate your Fifth Amendment rights. When you ask for production use immunity in that, and they take you in front of the judge then becomes your advocate. Let him be so. They'll sit you down in his chamber, the judge will tell the IRS to ask the question, you take the Fifth Amendment. Then the judge must advise you that the IRS will never use this against you criminally. Go ahead and answer it. He will repeatedly tell you right there, we have never heard anything out of the judge except, don't answer that. Don't answer that. You do not have to produce because it can be used in a chain of evidence to link you to criminal prosecution. He becomes your advocate. So sit there and drag him through the system. You'll learn how to protect your books and records from the Internal Revenue Service. If they can't get your books and records, they're in pretty short supply of anything, of being able to enforce anything against you. I'll even show you how to get all their documents knocked out if they put them in the court, because they're not accurate. And I'll show you 2 court cases where that's been done. But right now I'm showing you the Johnny Mayo case. Now here's the thing, what it got interesting in this case, the government knows my paperwork. They meet and they talk just like we meet and talk. They moved, when we moved into our lawsuit against them and started asking them for documentation under the laws of discovery, they moved for a protective order against turning any documentation over to Ken Hunter. And I wouldn't even name them in the lawsuit. But that's what they wanted, protection, because they figured out a long time ago that I know how to read your documents. So anyway, what we were after was documents from them. And we were specifically defining our documents that we wanted to see. And they didn't want to produce them. As a matter of fact, they told the judge that if he ordered him to produce these documents, and they already took Johnny's property now. They said if we have to produce these documents, it become potentially embarrassing to the United States. And we said, how could it become potentially embarrassing if you obeyed the law? Pretty impossible, isn't it? But anyway, they didn't want to give us these documents. So anyway, the judge denied their motion and ordered them to produce. What we wanted to see was the notice of deficiency, which is, this is part of it here, okay? If you want to take a look at this, you can see where they whited out somebody's name up here and typed in John A. Mayo. It's wrong type. It isn't even lined up. That's how sloppy they are in creating their paperwork. The first one they sent it out to Harrowhead, Illinois. Johnny never lived in Harrowhead, Illinois. They lived in Virginia. Okay? So anyway, through this thing, we said, okay, strike one. Going on through this thing, what we wanted to find out from them was what kind of a tax they were attempting to collect. Right? And right here it says kind of tax income. All right? Now this created quite a situation, because in all the notices of levy, notices of tax lien, they were attempting to collect what is commonly called a 1040 tax. How many of you know what a 1040 tax is? They probably took some houses around here off of a 1040 tax. If you look in the revenue code, there is no such thing as a 1040 tax. It isn't there. There is no such thing in the revenue code as a 1040 tax. Doesn't exist. What did I tell you the Internal Revenue Service can enforce? The revenue code. So if there's no 1040 tax in the revenue code, what in the world are they trying to collect here? You ever asked them? Well, I did. We asked them about this term income. We said, where in the world did you get that? Because Johnny never filed any returns. They said, well, we got it from here. Okay? Every one of you got one of these, I guarantee you. They're using it against you. Every case we're handling, we're now finding this little slip of paper. So you want to know where they got his income? Due to your failure to file returns and to provide adequate records from which your income can be determined, income is increased as follows based upon Bureau of Labor Statistics information. Is that a tax on the income by the 16th Amendment? Or is it a tax upon what the government thought he should have earned? Aha. Now we got it. Whoops. Is that now covered by the 16th Amendment? Or is it under Article 1, Section 8? Well, it's Article 1, Section 8 if they want to try to tax it. The man up in South Dakota, I went up to his place, and he says, look what they did to me, Kenny. He said they went out and checked all my, because he never filed any returns either, and farmers know how to steal from themselves, okay? So they went out to all the ranches around his place and determined what they had grown and then taxed him upon what his neighbors had grown. Now, is that a tax on the income? Or is it a tax on what the government thought he should have earned? I'm handling a case in Southern California right now, a chiropractor. The Franchise Tax Board sent him a tax bill for $45,000 because that was the tax on what he should have earned, right? He can just barely speak English. He calls me up and he says, I didn't earn that much, Kenny, because I took 9 months off and went on vacation. I only worked 3 months. So I got a hold of the Franchise Tax Board, people there I know, and I said, do you realize you're taxing this guy for a full year? Well, yeah, he sent a return in and it was wrong. He only claimed income for 3 months, and we know this is what he should have earned based upon Bureau of Labor Statistics information. I said, don't you understand a man took 9 months vacation? They said he should have worked the whole year. And it won't come off the tax bill. We're going to sue them. But they got the information from here. Bureau of Labor Statistics information. Because the government runs a survey, that's what they use the census for. They can tell you exactly how much money a chiropractor is going to earn if he lives in Marlborough, Massachusetts. And they can tell you within a few $100. So when your return comes in, if those figures aren't correct, they make a substitute return for you, and they assess you pursuant to that figure. Now, is that a tax on the income? Of course it isn't. It's a tax on what the government thought you should have earned. When did they ever get that authority? Now, believe me, this is part of official government records. This is where it came from. It came, matter of fact, it came under oath as a true and correct copy of the document. Under oath, the IRS went. Okay? So anyway, that's where we know they got this from. So we said, okay, on the notice of federal tax lien, on the notice of levy that they took Johnny's property, they claimed they had assessed a 1040 tax. If you know anything about the code, you know that the only thing that they can assess is a tax in the deficiency, okay? Now, the tax in the deficiency, well, I'll get it out, that I showed you was based on income. It was an income tax, okay? That was what it was for. But on the notice of levy and notice of federal tax lien, it was a 1040 tax, which does not exist. We stood prepared to make a citizen's arrest on the agent for making false documentation. So to protect themselves, guess what they said they did? This is another official government document under oath, and they said we assessed him a Form 1040 tax. We said, does a Form 1040 tax exist? And they said no. And I'll show that to you. But anyway, strike another one against them because it says right here, I certify that the annexed transcript of John A. Mayo herein with respect to Form 1040 taxes specified as a true and complete transcript, boom, down the line. All right? A 1040 tax. Now, if you want some documentation from the IRS, get this one. Certificate of assessment. This is where they have actually assessed something against somebody. The taxpayer must be named, must have a city, the whole 9 yards in there, and it must be signed by an assessment officer. And the assessment officer must have the authority to make the certificate of assessment and do the assessment. All right? This is it here, right here. In 91, they made a deficiency, which I just showed you, against Johnny. And down here, on the same day, they gave him a notice of assessment under 6303A, which notices of deficiency clearly give you 90 days. There can be no collection activity, no assessment made, no nothing made until 90 days have passed from the date of the deficiency. They admitted under oath that this right here was the notice under 6303A of the Certificate of Assessment, clearly in violation of their own code. This is the official document under oath that this is the Certificate of Assessment, Johnny Mayo. You see a signature right here, all right? You know what that signature is? That's the signature of the certification unit manager. And you know what he's certifying to? That there's ink on that piece of paper. That's all it says. Is there ink on that paper? Sure there is. You just certified it. I can certify it. But there's no signature of an assessment officer. So we said, when was the assessment made? They want answers. They have no assessment officer to bring forth under penalties of perjury that'll say he ever made this assessment against John Mayo. This is where you hang them up, is in their own paperwork. Most of the time it never gets this far. But anyway, through this thing, page after page after page of nothing verified, nothing made by the assessment officer, the whole 9 yards. So then we got into some more pertinent questions having to do with notices, points of discovery, and the whole 9 yards in the Mayo case. They told us that since the notice of deficiency was sent out to Harold, Illinois, that the only thing they had to do was put it in the mail, and you had the obligation of getting it. Well, that's contrary to the code, folks. If you don't know you owe a bill, are you going to run down here and pay it? Somebody's got to send you a tab, folks. That's how it operates. The IRS sends you a ticket. If you don't know the ticket's there, you can't pay it. If you don't have an opportunity to know that they've assessed you something, you don't have the opportunity to go to tax court. If you don't have the opportunity to go to tax court, it's a major deficiency in the IRS claims. They must afford you the right to go to tax court whether you want to go or not. If you don't know about it, you can't petition the court. So they said, well, we don't really care. We said, have you ever seen this document? He says, yeah. Johnny says, is that part of your regulations? And he said, yes. Now understand one thing about regulations as opposed to statutes. This is another place where a lot of people get hung up. Regulations only apply to the agency. That's all. They do not apply to you. It's only what the agency has to do. Okay? We have this out of him under oath. Dick Stein got it. It's in his book, Judicial Tyranny, the whole 9 yards. That all these regs do is control the agency, not you. All right? So anyway, we said, have you ever seen it? He said, yeah. Okay. It says the burden of proof and establishing the date is on the commissioner. Accordingly, it is necessary that a record be maintained by each district director showing the dates on which notices of deficiency were sent by certified mail. Okay? Now, Congress stated in their comments when they ordered this thing written that it was to keep honesty in the taxing system. They wanted it so honest that they didn't want to believe the Internal Revenue Service agent, so they said, you go down to the post office, you will take the notice of deficiency, you will get a PS Form 3877, the little white slip that you get for certified mail, you get a little green card, you will give the notice of deficiency to the postal employee who will fill this out, he will put it in the envelope, he will address it, and he will mail it, so he can be a qualified expert that it was sent to you certified mail. Says it. We say, did you ever do any of that? No. It also says here that when you sign the green card and it comes back to the agency, it is attached to your permanent file, which will be made available to you upon request. We said, do you have the green card? They said, no, we don't keep those things. If they don't keep the green card, folks, how can they prove you ever got it? How can they ever prove that you ever received this thing? They can't, can they? Who is the burden of proof on? Commissioner. That means he has to prove you got it. If he can't prove you got it, they're in violation of their own rules. So anyway, he says, that's okay. We got you on the notice of assessment. Now this is 6303A. They've always told us that on the notice of assessment, we don't care whether you get it or not, because there's no requirement under the statute that says we have to care. We said, have you ever seen this? No. They gave us all this stuff under oath, and we said, do you even obey any of it? They said, well, some of it we don't think we have to. Well, anyway, it has to do with 23C assessments, what I just showed you. Assigned by an assessment officer, all right? And it says, and I didn't write this thing, I was laying at home at night and having a nightmare over this. It says the notices will be maintained separately and manually certified and mailed with a shipping function. So how are you supposed to get the notices of assessment and demand for payment under 6303A? By certified mail. Again, you got a little green card. The whole 9 yards now comes into effect. They must send it by certified mail. It must be manually certified, and it must be done by the shipping function. So we said, who is the shipping function? They said, that's the Postal Service. So then how does it have to be done? You've got to take it down, just like I read you, on the notice of deficiency, you give it to the postal employee, he fills out the 3877 form, and he puts it in the mail, because they don't trust the IRS to do it. That's what it says, all right? It not only says, it says, information from each notice must be maintained in a log by mailing services. The log must contain the taxpayer's name, address, city, state, zip code, date, mail, and certified number. We said, did you ever do any of that? And they said, no. Never did any of that. Well, what is the first requirement of income tax evasion? You must know you have to owe them something. And how do you owe them something? They make a deficiency and they send the notice of assessment. Those are the two first indicia in income tax evasion that 99.9% of every lawyer in America doesn't know. Make them first prove that you knew you owed something. If they can't prove you owed something, how in the world can you evade it? Huh? You're out of the court in the New York 2nd. for pity's sakes. Because they can't prove you owe them anything. It's kind of like they're suing this guy now for fraudulent conveyance, and they can't even prove there was a conveyance. And I said, if they can't prove there was a conveyance, how can there be a fraudulent conveyance? Doesn't that stand to reason? So anyway, we got down now into some more discovery, and we got to asking them some pertinent questions, all right? This one here, we got a big laugh out of this. Gary Allen, Assistant U.S. Attorney, told me that he had to go to 17 dictionaries to get this definition. And I said, Gary, who in the world ever said these people were an authority on the English language? And he says, well, nobody that I know of, but it sounds good. It supports our position. The Congressional Dictionary Act that I showed you up here on the board doesn't support his position, right? So anyway, they put this in and we laughed. We thought it was kind of humorous. But what we asked him was the definition of a term person. And he says the principal dictionary definition of the term person is a human being. And it established American Heritage Dictionary, 2nd College Edition, Dell Publishing Company, 1983. Did you know that Webster has never been classified as an expert on the English language? So who in the world is this guy? Who in the world is he? But anyway, we thought it was humorous because we had him beat in so many other areas that pretty soon you have to just get down to taking 2 or 3 and getting on with it. So anyway, all the definitions I showed you up on the code book here on the screen having to do with 7701A30 and whether or not the term individual was found in those 4 sentences. All right? A, B, C, D. That was the main issue that I want to stress there. Well, now you don't even have to take my word for it. You don't even have to take the word of Congress when they made the statute, because right here they told us under oath that it does not mention the term individual. And this is from their head tax lawyer in Franklin Station, Washington, D.C. Under oath. All right? So anyway, it isn't there. So then we got down and we asked them specifically about the 1040 tax. And these are all pages out of Discovery, which is it's a legal questionnaire you can send to the other side, they can send to you, and you ask questions back and forth. What we wanted to know was did the 16th Amendment allow for a 1040 tax, and what specific section of the code stated that there was such a thing as a 1040 tax? The term 1040 tax does not appear in the Internal Revenue Service Code. What can the Internal Revenue Service enforce? Revenue Code. The man's now just admitted it's not in the Revenue Code. So what did they assess Johnny Mayo? A tax not in the Revenue Code. It's not in there. It is not there. If it's not under the 16th Amendment as a tax on the income, does it then come under Article 1, Section 8 that must be apportioned by census and enumeration equally throughout the state? Sure it does. Absolutely. So anyway, we're getting after these people. I won't go into this next one. It's a long, lengthy thing. It has to do with placing of a notice of federal tax lien that can only be placed within 10 days after making personal contact with you. But I won't go into that. It's a lengthy thing. So anyway, I'll show you some more of this stuff here. I'll put a couple of areas I want to cover. This has to do with the Lang-Rear case in Nebraska. All right? Certificate of assessment, just like I showed you in the Johnny Mayo case. There's only one thing missing. You don't see any signature at the bottom of that date. It isn't there, folks. Simply is not there. When we asked them under oath when they did the deficiency, which they stated to us that the deficiency was done on 7/21/83, and right here is where they made a substitute return. Remember me telling you about the substitute return? This is where they made the substitute for Harvey. It was done on 7/21/83. We asked them under oath then when they sent out the notices of this. All right? They sent us out and told us that the first notice was sent, the fourth notice was sent on the same day that the deficiency was made. The fourth notice. We said, when was the first, second, third sent? Well, that was sent after the fourth notice. Right? Now, just to top this thing off, they told the same thing to the federal district court judge. And he ordered that the notice of deficiency was made on the same day that the certificate of assessment was made, and the notices were sent irregular. They cannot make the assessment until 90 days has passed from the notice of deficiency. That's your 90-day ticket to the tax court. They can do nothing to collect that within that 90-day period of time. And now here under oath, they said they did it. The judge agreed. Right? So anyway, we're having a lot of fun with that one. This one here has to do with the Bodwell case in Sacramento. Now this one really gets interesting. Okay? The Bodwells filed returns. Okay? This is a big difference between Harvey and Mayo. They filed returns. Okay? It says right here, return filed, the amount, assessment, and the payment the Bodwells sent in with the return. Okay? It's your government in action now. This was all done 11/10/80. Return filed, payment made by their own records. Okay? 11/10/80, they estimated a tax penalty of $54. On 11/10/80, they hit them with a late filing penalty of $312.50. Failure to pay tax penalty on the same date of the $1,250. Failure to pay tax penalty, they assessed them $12.50. Then they wrote down here that they had a payment of $464.89. Then they made a deficiency of $8,553. Now remember, they filed a return and they sent the money in, just like most people do. But now they're upside down, $8,000. Government in action. They then cited them on the same date, all right, interest of $8,137. Boy, now that's heavy interest. That's 100% interest for a 24-hour period of time. So then, fees and collection cost was $10, right? Then on 7/14/86, they sent the fourth delinquency notice. Okay? Fourth delinquency notice. They sent another fourth delinquency notice on 2/23/87 and 10/12/87. Then on 11/2/87, they sent the first delinquency notice, and on 12/07/87 they sent the second, 6/27/88 they sent the third, and then 8/01/88 they sent the fourth notice back again. Government in action, okay? Nobody anywhere signed the certificate of assessment. The courts have repeatedly ruled you cannot put out a notice of federal tax lien until you have an assessment. There must be an assessment, then the lien follows, and then the levy follows. If they do not do any of these things, would the term theft enter into this anywhere? If they didn't obey their own law and make a proper assessment, does the term theft enter into this? Absolutely. Most definitely. And that's where we're hanging them up. Because once they come outside this code and start all this junk, are they then protected by the code? Of course not. I got after this one guy. He was claiming to be a non-resident alien, and I don't want to get into that, but I'm just going to give you this little story. That he was a foreigner to the Constitution, the laws of the United States, and the whole 9 yards, until they threw him in jail. Then guess what he said? I gotta have protection from these statutes, I must be a citizen. I said, how can you be one and claim to be the other? Can't, can you? Any more than what the IRS can. They're bound by their own code. They're bound by written statute. When you take that written statute into court, the judge must honor it. The law speaks for itself. It does not need to be interpreted by anybody. It speaks for itself. Matter of fact, if you're in a court case, ask the judge to take judicial notice that the code speaks for itself. He'll tell you, I don't have to take judicial notice, it does it anyway. Means he must obey it. We're after federal district court judges right now because they're not obeying the code. When they're in violation of the law, it says in there that they hold their office during times of good behavior. In other words, they can't be put out except impeached for violation of the law. That's what they've determined it to be. But it clearly says they can't hold office except during times of good behavior. So if they violate the law, can they hold their office? Of course not. And we're after them. Matter of fact, up in Spokane, Washington, the senior judge up there, the Idaho State Patrolman arrested him in Idaho for going eastbound in the westbound lanes of I-90. The patrolman pulled him over and he said, "Oh, I know why you pulled me over, my bright lights were on." Well, the only thing bright was his nose. He was soused. They threw him in jail overnight and nailed him on a misdemeanor. And now we're asking him to step down. He just had a major heart attack because we're saying you're no longer holding your office in good behavior. How can you have a law violator on the bench judging law violators? Can't do it. The other judge up there, in Spokane again, he goes down to this Spanish restaurant. This is at 5:30. He closed court at 5. He walks into the Spanish restaurant and he orders a shot of Jim Beam whiskey with his dinner. She says, "I don't serve whiskey here. I can only serve beer." Wherein he proceeds to pull out of his coat pocket a Jim Beam bottle and drinks it down, soused to the gills, at 5:30. All right? She calls the cops and they arrest him for having hard alcohol in a beer establishment. They convicted him of it and fined him $100. And now we're after him because he no longer holds his office during times of good behavior. He's a law violator, irregardless of what the law was. So we're after these people. We know now how to get these people in front of the Judicial Committee and to get them reprimanded. And we're flat dab after them. From the, okay, go ahead. I'm going to turn the tape here. Got it? Okay. So anyway, we're after these people at both the state and federal level that they must obey the code. Not interpret it, not do anything with it, other than obey it. This one guy went back in front of George Abatement. He had been a tax protester all his life. He's protested everything. The ratification of the 16th Amendment, the whole 9 yards, and he goes in front of Abatement and he loses. He found out about me, retained my services, and I sent him back to court to stand on the code. He's standing in front of George Abatement, and Abatement says, "Wasn't you in here a few weeks ago telling me none of this applied to you?" And the guy said, "Well, I was mistaken." He says, "The law applies to me now." And Abatement looked at him and says, "Well, now you've got an argument that we can hear." And the thing is still going on up there. Now we have an argument that we can hear, because now we have specifically pointed out how the Internal Revenue Service has violated the own code. Flat violated. So we're after them on it. So anyway, through this thing, and that, I want to read some court cases to you concerning what the courts are saying about these people, what the courts are saying about their documentation. The Blackstone case in Maryland is very strong. And what they're literally saying in this thing, and you can get all this stuff through Lexis and Nexus and that, they're literally telling us that the IRS computerized records are worthless. Don't even bring them down to the court. If you understand what happens here when the IRS wants to bring like an individual master file or something like that into the court system and try to convict you of willful failure to file, income tax evasion, or anything else, move to strike the whole 9 yards because it's irrelevant evidence. They can't get it into court. And what happens here is in Martinsburg, West Virginia, there's a computer down there that is known as the MCC computer. It's an ADP code on a magnetic tape. They have a list of all taxpayers down there. When they want something on one of you or whatever, they will then ask that computer to duplicate itself, It will then duplicate that section of the tape, and that section of the tape will be mailed to the local service center. The local service center will then make another tape of it and hand it to the district director. It's still an ADP code. The district director then will make another tape and transcribe it over to the service center IRS code under what is known as IDRS computer code. Then somebody comes along and translates some IDRS computer code down to English to get these papers that I showed you into the court. That's where it comes from. It's off the IMF file. If you look at what happened here, the bottom line of this whole thing is that these are nothing more than documents made from a translation of 2 or 3 duplications or translations of an MCC code out of Martinsburg, West Virginia. When we brought this to the court's attention, and several other people did the same thing, the judge ordered that tape from Martinsburg, West Virginia into the court to determine its validity. The IRS said, "We'll see you later." They have never brought that tape into any courtroom in the country. The reason being is that the thing is so full of errors at the top that by the time it gets to the bottom, the errors are compounded. One judge in one case said, "It appears to me that these translations are nothing but favor to the IRS," and threw the whole 9 yards out of court. In this Blackstone case here, they followed the Berman case, which I've been told is overturned now, but that's okay. There's many cases out there to take its place. As this court finds from the evidence presented here, there are sufficient irregularities presented in the IRS computer evidence to cause this court to doubt its reliability. Therefore, the court refuses to accept the records as conclusive. In particular, the court notes that the IRS records reflect the mailing of a first notice on January 20th, 1985, and the mailing of a second notice some 4 months later on May 31st, 1985. However, the IRS Service Center computer is programmed to send the second notice 5 weeks after the first notice. Now, remember the notices I was telling you about? That I read you in the vaudeville case and the Langware case? That's the notices they're talking about. This whole thing stemmed around 2 days difference. Because that computer is programmed to do certain things in so many day cycles. All of a sudden, it's out of cycle. If it's out of cycle, it's programmed wrong. And that's what the court recognized and ordered it forward. They refused to bring it forward. The court interprets this response to mean that the government cannot provide any satisfactory answers to the court's question. Therefore, on the record in this case, which includes the government's refusal or inability to provide an explanation of the inconsistencies of its computer-generated records as to the date of the first notice, the court finds as a fact the IRS did not comply with 6303A, which is the notice of assessment and demand for payment. Remember, they sent the 4th notice first, and that on down. Did they do the same thing there? Sure they did. So the government, the courts are saying one error in the entire individual master file, does it then invalidate the entire file? Yes. That's all it takes. One error in this whole thing, and it's all gunny sacks. Because it's all based on an error. And one error compounds itself, and compounds itself, and compounds itself. Right? So all you do is start very subtly asking questions, getting documents from these people. As a matter of fact, Buford, in the case U.S. versus Buford, Buford was convicted of willful failure to file and was in jail. He said, "I sent you the return. What did you do with it?" The IRS couldn't prove they didn't have it. The burden of proof is on the IRS. They're trying to convict this man and had him in jail. He said, "Hey, what did you do with my return?" When I lived in Washington, I broke in every new IRS agent in that area and sent them out to my house. Okay? Now, I don't recommend that all of you do this, but I had a lot of fun with them. This one guy, a particular guy, came out, and he knocks on my door, and he wants to talk to me about some business that I had going on at that particular time. And I said, "Come on in," you know. And the guy's looking like this, you know, because he thinks I got a big dog waiting behind the door. You know? No, I said, "Come on in," you know. So I got him inside there, and we had some coffee. We sit down and chatted. And when that man left, he was about half educated. So I told him, I said, "Hey, don't drive all the way out here. I said, you want to talk to me again? Give me a phone call. I'll come down there. And he looked and he said, you mean you'll come down to the office and talk to me? And I said, oh, without a doubt, just give me a phone call. So he wanted to know something else about this business I was involved in because I was running stuff across the border into Canada. So anyway, he calls me up and I say, hey, I'll be right down. So I go down to the office, I walk in, and I say, you got a Form 1157? And he says, well, no. Why do you want a Form 1157? And I said, so I can bill you for my expert tax advice. He says, no, you see, you don't understand, we're here to talk about your tax problem. I said, I don't have a tax problem. I said, you called me down here to give you tax advice. I must be an expert, I'm entitled to be paid. So anyway, he didn't know what to do. So he goes in the back room, and all the old guys know me, they're back there going, you know. The poor guy come out, he ends the interview right away. He don't know what to ask me, what I'm going to tell him, or anything else, you know. But I have a lot of fun with these people, just talking to them. Well, that's what Buford learned to do. He said, hey, I did this, and he said, gee, you guys must have lost it. Because every time